Can I start? Okay, thank you. Morning, everybody. I'm Lucio D'Amario. I'm a partner at Linklaters. It's a pleasure being here today with you. I would like to thank you, Lear, for the opportunity. We have a session now which is structured into parts. In the first part of the session, we will tackle behavioral issues concerning new challenges for in-house counsels in this space. We will discuss some aspects deriving from the implementation of DCM Plus directive, in particular with the focus on memberships on trade associations and sustainability issues. We will discuss this with Daniele Guarnieri. Daniele is General Counsel at Nestlé, Italy. In the second part, we will instead address merger control issues, again, from the angle of what is very relevant to date for an in-house counsel. We will focus and tackle Article 22, Fdi regimes, the increasing importance that these regimes have had recently. And we will discuss this with my partner, Annamaria Mangiaracina, and with Valentina Laroccia. Valentina is head Anticorruption, Antitrust, and Financial Regulation Compliance at Plenitude. So, starting from the behavioral angle, we know that the recent implementation in a number of member states of the ECM Plus directive, and in Italy recently in December with Decree 185, has essentially strengthened the powers of national competition authorities, has fixed certain shortcomings. We will not discuss this in detail, but in terms of powers, of course, certainly now national competition authorities have increased powers to effectively detect and tackle competition law infringements and have been enabled to impose effective and strong fines. In Italy, in particular, trade associations have been affected under this angle, but not only trade associations, also their members have been affected in a number of ways because Decree 185 increases the maximum amount of fine that can be imposed to association of undertakings, up to 10% of the sum of the total worldwide turnover of the members active in the market affected by the infringement. But it also affects the recovery of the fines imposed on trade associations with the new principle of financial responsibility for the members of the association in case the association is not solvent. So there is a direct exposure for the members themselves rather than the association only. And if contributions are not paid in full within a set time limit, the authority might directly require payment by any undertaking whose representatives sat on the board, where members of the decision-making bodies of the associations. And again, if necessary, the authority can also require payment of the outstanding amount of the fine by any member of the association which was active on the market concerned, with certain exceptions whose burden of proof, however, relies on the undertakings themselves. So, what has happened in Italy in this respect? Decree 185 has brought the regime of fines for association of undertakings in line with the rule that we already had in Brussels. So Article 23 of Regulation 1, 2003 already, had a very similar system. So, is this big news for Italy? Well, probably yes, because if we see at what has happened in terms of statistics in Brussels rather than in Italy, you notice that in Brussels between, say, from 2010 to date, cases involving associations of undertakings have been absolutely exceptional, absolutely exceptional. Whereas in Italy, if you look at the last 5-6 years, so say from 2017 to date, almost half of the cases, 101 or Article 2, have involved associations of undertakings. So the margin of risk is different in terms of cases which have been under the radars and probably will be under the radars of the Italian authority. It's not only the Italian authority. Similar trends have been, we've seen similar trends in other jurisdictions. So for instance, France, again, from 2017 to date, they've had dozens of cases involving associations of undertakings. Now, this legislative change comes at a very particular time because it comes at a time when antitrust authorities, around the world are again starting to refocus on behavioral infringements and also in new areas such as sustainability, given the climate emergency is reshaping also political agendas globally. And in this context, trade associations, but also other groups, I'm thinking, for instance, about the net zero alliances, have a very important role to transition to a low carbon future. However, as we all know, it might be difficult for undertakings, for even big groups, to make impactful changes alone. So, while certain discussions with competitors are clearly legitimate, others are risky, and the exact level of risk is being subject, it's a topic of recent debate, particularly in relation, again, think about the recent debate around the net zero alliances. We all know that emission-reducing technologies are very expensive. We know that a company taking a positive action alone may face a cost disadvantage, and that might disincentivize individual action. So what have the regulators been doing in this respect? We all know that at EU level, the European Commission has taken the lead. I remember when I was a young trainee or lawyer, it was end of the 90s or beginning of 2000, the washing machine case from the European Commission, where basically the Commission authorized the washing machine companies to agree stopping producing, in effect, non-efficient washing machines. That was probably one of the first interesting decision. But jumping to date, the European Commission has taken the lead with cases such as detergents, trucks, car emissions, although these cases do not involve associations of undertakings. We know that in March this year, the Commission has adopted a new draft, horizontal guidelines, which aim to provide guidance also in this respect on how to assess sustainability agreements. So at national level, the situation is more fragmented because certain national competition authorities, such as the Netherlands and Greece, for instance, have adopted a more progressive approach, a more open approach to counting sustainability benefits. So they've been quite prone in advocating a more flexible interpretation of competition law in this respect, whereas other national competition authorities have been less straightforward, if you like. So interpreting the fair share for consumer requirements in the EU exemption criteria quite narrowly and emphasizing the need to prevent illegal behavior stifling green innovation. So a couple of flashes. France, the French Competition Authority published a report in September 2021 on trade association and competition law. Focus on trade association and their members is also highlighted in the French Competition Authority's recent guidelines on compliance programs published in May this year. And interestingly, very recently, this month, the French Competition Authority formally appointed the first head of its Sustainable Development Network because probably it expects an increase in compliance and queries, at least, around cooperation between competitors in this issue. Germany, Bundeskartellamt, very active. We've taken a look at just what has happened this year, 2022. In 2022, the FCO concluded the examination of 2 separate business cooperation and sustainability initiatives The first one to introduce living wages in the banana sectors, essentially including a common standard of responsible procurement practices. And the second one concerning the expansion of the animal welfare initiative to reward livestock owners who are able to improve conditions under which animals are held. The 6th of September 2022, German sugar manufacturer case, probably slightly different angle. There is a bit of even an emergency situation here, but the FCO authorized German sugar manufacturers to provide each other with free production capacity if energy management measures imposed by a government led to a reduced or suspended gas supply. And just a few days ago, last week, again, the FCO looked into competitor collaboration and gave its green light to the joint operation of LNG terminals by Germany gas wholesalers. So it seems that the Bundeskartellamt is pretty willing to react quickly, pragmatically, and in particular, giving advice to the companies. UK, the CMA has published, as you know, a number of pieces intended to guide businesses and trade associations. We've got the guidance on sustainability agreements in 2021. March this year, the CMA gave its advice to the UK government in its environmental sustainability and UK competition and consumer regimes. Essentially, it proposes to launch a sustainability task force that is expected to develop formal guidance across the CMA's functions. And to conclude, in Italy also, has recently shown interest in this space, touching upon sustainability issue. I'm thinking, for instance, about the Corepla case in 2020. But we shall see what the future will offer us, what will happen also in light of the implementation of the ECM Plus directive and the recent changes that I mentioned earlier. So, no doubt in this unfolding situation, many challenges await in-house counsels. So I leave the floor to Daniele Guarnieri to hear his views. Thank you.
Thanks, Lucio. Thank you very much. I'm here to, give some thoughts on trade associations, in particular with respect to ESG, when discussing ESG by members of the association from the view of the in-house counsel, all right? I'm not a competition expert, so most of the thoughts that I'm sharing with you are based on really, real life experience more than, books, and you will forgive for that. First of all, let me say that, trade association for in-house counsel, at least for me, have always been a sort of an area of concern long before this directive, right? I'm not blaming the association. I value their role within the business category. They play an important role, actually. But it's undeniable, as you rightly said, that some of the most significant investigations, at least in certain jurisdictions, and unfortunately Italy is one of them, originated from trade associations, right? So I've always been, if not concerned, but I've always been very attentive when dealing with this aspect of the life of a big group like Nestlé. And I must say that being a Nestlé is, let's say, far more delicate, as a group like this is operating in different categories. So we deal with different trade associations, from water, coffee, pet food, health science. So, and not all the trade associations have the same degree and awareness of certain issues, such as antitrust. And yes, you're right. ESG is a hot topic, and more in the last, I would say, 3, 4, 5 years, this is a topic that is more and more discussed by trade association. Why that? Because even huge groups like Nestlé have realized that alone we cannot tackle certain problems. And I'm particularly referring to environmental ones. So we need to join forces in order to do what consumers expect first. I mean, we receive questions by consumers say, what about exhausted capsules? What about these bottles? What are you doing for that? So, I mean, and we alone, even if we are the biggest in many, many countries, we can do little. We can lead, right? We can take the lead for advocacy and so on. But again, we need to join forces. And so trade association is a natural environment in order to do so. But also it's a risky one. And because, you know, it's not like the usual old school trade association environment whereby you had the head of sales complaining about the squeezing of their margins and say, and they come up with a brilliant idea. Why don't we jointly raise prices? No, it's not like that. Maybe it used to do that also back in the past, but still. Here, I mean, here the purpose is good. It is. I mean, it's really to do good for the community, right? But as the philosopher said, I think it was Karl Marx, I mean, the road to hell is paved with good intentions, right? And so, I mean, my fear is when you're there, I mean, and discussing good projects, you also jump in, I mean, sensitive, I mean, arguments. And here comes the role of the in-house counsel, okay? What is it, the role of the in-house counsel? Well, it is, I think it's a pretty important one, I would say, in many fronts. First of all, I think the preparation work is essential. So having in place a solid antitrust guideline, general, an internal one is key, right? In order to show what are the main concepts underlying antitrust law is key, again. Not only for obtaining a decrease of a possible fine, as the law provides, but also to avoid possible fines when tackling these sort of topics. Then, another one is to know the project very well. This is another fundamental aspect, because some of the projects involve many stakeholders, are complex. They involve not only competitors, but they involve the trade association, they involve municipalities, and you really need to have a solid grasp of how it works. Otherwise, the risk here is that you miss some part that may afterwards reveal problematic, right? What I do personally is trying to figure it out when discussing with my colleagues the possibility of a project. I try to figure out a list of, let's say, arguments that are, to me, a hardcore no way. Some of which may be quite straightforward. Okay, no way that you will align on you will discuss prices. Okay, that's fine. But some others, I mean, they are not that straightforward. I mean, agree not to advertise sustainability claims afterwards. No, let's decide that we are doing that, but we won't use these claims in order to do advertising. This is, I mean, not that immediate, but in the end, it's something that should be avoided, definitely. One other to me, important issue to take into account is to be very transparent vis-a-vis the outside on why you're doing that. So very clear on the topics, on the purpose of the project. Not only, I mean, also in the documents that then they will build the file, right? It must be clear-cut that the purpose is, I mean, a good one, and you never miss it while discussing with your competitors. By the way, I mean, we always have in mind these projects with competitors, but it may be downstream or also upstream, right? I mean, you may undertake projects with other key players of the value chain, and the rules are the same. I mean, obviously. Then it's key to make sure that the information exchanged, if any, but most of the times you do, are reduced to a minimum. I mean, the minimum information that you need to exchange for the success of the project and not further, right? And it's also key to use, when needed, a third-party independent figure that can receive certain information and in order that there is no direct exchange of information, then it transforms the information in an aggregate amount in order and not to be reverse engineered in order that you are not, no one can claim that there was a specific transfer of unlawful information. And finally, the in-house lawyer has an important role also within the organization in order to win certain internal forces that are natural while dealing with competitors for a purpose, for a ESG purpose. Because sooner or later during the project, the marketing guy will come up and say, why are we doing that? Yes, I know that we are doing for this, but why should we give a favor or advantage our competitor? No? So, and then a negotiation, a proper negotiation starts on, no, you do this because I've done that, no, and so on. There, to me, the in-house counsel should remove the hat of the only legal advisor and urge everybody in the room not to forget why we are there, right? Because it's a higher purpose than the companies. Obviously, the companies are embarking in such projects because they are bound to, no, like it or not. But you should not forgive that this is for a higher purpose.
Thank you, Daniele, for having shared, the view from the inside, importance of compliance, the importance of being prepared, the fact that a general counsel needs, or an internal counsel needs to deal with many stakeholders and all the complexities. Thank you. So we move to the merger control session.
Thanks, Lucio. Thanks, Daniele. So just for a bit of a longer introduction, 2 seconds. So I'm Annamaria Mangiaracina. I'm one of the partners in Linklaters. I'm based in the Brussels office, and I'm joined today by Valentina Laroccia. Valentina is currently the head of Anticorruption, Antitrust, and Financial Regulation Compliance at Plenitude. And for those who don't know Plenitude, Plenitude is a company within the Eni group that currently owns what used to be Eni Gas e Luce, the renewable services of Eni, and since last year also NEB Power, so the recharging business when you go around the city. Valentina is an antitrust expert. She advised in proceeding before the Italian Antitrust Authority, European Commission, and also more globally. And importantly, she's, from what I know, because we've been working together a lot, an expert when it comes to merger control matters in terms of international joint venture, acquisitions, divestments. Previously, before joining the Plenitude team, she was the head of antitrust, market analysis, and energy regulation compliance at Eni, so the E&I group. So as Lucio said, what we want to do is a bit of a shift of gears. So we go from antitrust to merger control. And I think what we like to do with Valentina in this session is really kind of bring about what are the current challenges when you are an in-house counsel, and I should say also when you are the external advisor, when your client tells you that they are thinking about a merger control, at least a transactional project. And the key takeaway for us is that currently there are a number of factors that lead us to conclude that timing and advising clients, be it an external client or internal client for Valentina, on timing and feasibility of deals becomes more and more challenging. So I'm just going to run through what I think are some of the factors from a regulatory perspective that brings this challenge. So first and foremost, and I think there will be other sessions during this conference about it, is the new European Commission approach in the application of Article 22 of the EUMR. So Article 22 gives the possibility for the Commission to review transactions which are being referred up. So National Competition Authority asked the Commission to look at a matter because they believe that that case will bring anti-competitive effects across the markets. And back 2 years ago, in March, actually it was a year and a half ago, March 21, the Commission issued this new guidance on the application of Article 22, which raised a lot of criticism, I must say, from the antitrust community, whereby the bottom line is what the Commission is saying is, look, if there is a matter, a case and a transaction that doesn't meet jurisdictional threshold, so think about it as an in-house counsel, that means you don't have to notify. If you, antitrust authority, believe that the transaction, because a number of factors, which is, it affects a competitor that has an important competitive role, it's in a market which is very innovative, it relates, for instance, to the digital markets or healthcare. In any event, there is something that says that this company, which is being acquired, actually has a role in the competitive dynamics which goes beyond the turnover, which, as we know, is the only threshold that applies at EU level. You, antitrust authority, can ask me, Commission, to look at it, and I would be very keen to look at it. So that, of course, created, I should say, chaos from the practitioner point of view, because you are effectively asked by a client, look, my M&A team tells me that they want to buy X. X has no turnover in Europe. X actually is just a pipeline. They're just developing a pipeline drug. The pipeline is in phase 3, which for those who do healthcare space means it's far away still from market. Shall I notify? Should I worry about merger control, or can they go ahead and close in 2 weeks? And the answer, probably until this guidance, would have been, yes, sure, goes ahead. There's no real impact. You look at national level, all it looks good. The answer now is quite different. The answer now is, can we please look at what is this pipeline, where this pipeline sits, which is the market, are there other players, is the target the only one developing this drug, is the drug going to be very innovative? Because if that's the case, I'm sorry, I think we have to consult the European Commission to see whether they want jurisdiction. And why we would consult? Because, again, we are in deal terms where you all know that timing is essential. You want to make sure that you don't find yourself 6 months ahead, you have already completed, and you get a call from DG Com saying, actually, a number of national competition authorities have asked me to look at this case. So your deal has closed the deal, everything, you're starting to think about integration planning, and you find yourself there thinking, oh my God, now I have to go through a commission review. And this is what happened to what is probably one of the most discussed cases currently. It's Illumina Grail. This is an acquisition in the healthcare space, which was announced back in September 2020. They announced the deal. The acquirer, the target, Grail, is a company which is developing assets, has no turnover in Europe, in none of the European member states. So they went ahead and said, look, we're going to close. But actually, this fell really straight into the new guidance and issued by the Commission, and a number of national competition authorities in Europe, led by the French competition authorities, said actually, even if you have no turnover, which means you wouldn't need to be subject to the merger control review by any member state, we want you to look at this. You, Commission, should look at it. This is a very innovative product. This is going to be driving innovation. It's about cancer detection. So you need to look at it. Bottom line is, after 18 months, 2 weeks ago, the Commission prohibited the merger. The parties have already implemented, went ahead and closed. They are currently undergoing 2 proceedings. One is for infringement of the suspension rule because they went ahead and closed. The other one is because they have, they just didn't wait for the Commission. So the bottom line is what happens. As external counsel, this new enforcement policy creates a challenge because you need to effectively do a pre-assessment on the substance of whether the transaction will have some competitive effects. Of course, this doesn't apply to all markets, but when we think about innovation, I mean, innovation is quite of a wide concept. So if you are buying, saying, a startup, it doesn't matter which is the sector, the reality is that you might find yourself in that space. And I don't even have to go what happens if you are buying out something in the digital space or in the healthcare space, which are 2 of the key sectors which are named by the Commission. So this is the first piece in terms of uncertainty. And I should say this doesn't apply also at EU level. You will have seen that Italy, with the new Legge Concorrenza in August 2022, they have introduced these call-in rights. So they've sort of implemented at national level what is the Article 22 guidance. So this is also going to apply at national level. So just that this tells you that actually there are a number of national competition authorities that are quite keen for this guidance to take place and kind of to be implemented. And I'm saying that because there are, vice versa, other national regulators like the German Bundeskartellamt that have said that they do not have the legal right to refer transactions that do not meet jurisdictional thresholds, so they find that that's challenging from a legal angle. So I think that's the first when it comes to merger control. The second challenge, or at least the second element to the, when you're advising, is the FDI regime. So you all know that, we went from notifying 0 to having the FDI timeline running together with your merger control. So if you are in a business like Valentina's business, actually notifying for foreign investment becomes very important. You have a number of proceedings. You have European member states that, sooner or later, they will all have their own FDI regime. And we looked a bit of stats. I think in 2020, you will know also that there is a framework whereby national ministries or whomever is in charge for the foreign direct investment review communicates across themselves within Europe. And so we looked at a bit at the stats, and back in 2020, there were 265 notifications across Europe, and in 2021, this jumped to 414. This means that there have been filings. What we see also in practice is that you notify to X number of jurisdictions, and then all of a sudden a number of others, because they hear about the transaction, they start sending you RFIs through, the regulator that do have jurisdiction. So this adds to the, to the timing factor of how long it's going to take, and you try to answer this constant question from the business. Yes, but how long it's going to take to get clearance? Can we close? Can we close tomorrow? And you effectively have to tell them, look, we need to get clearance also from the FDI, which is the novelty of the last couple of years. And Italy is quite of an active jurisdiction, if I may say, when it comes to golden power. And in 2021, we had 3 veto transactions. So we don't just see this as a procedural element. Actually, if you are doing an investment in some sensitive sector, you might actually find yourself with a prohibition. So, from a client angle and, from the internal team, this becomes an additional layer of complexity. And last but not least is the new regulation on foreign subsidies. As you know, this is a project that is quite dear to the European Commission. This is about trying to create a level playing field for European players. So the idea is, if you are coming to invest in Europe and you come from abroad and you have received some sort of subsidies from external that I should say subsidies also, for instance, a tax regime which is more advantageous of European companies, you need to notify to me. And you need to notify to me also in a merger case. I won't spend a lot of time on there, but just to say that a point of notice, the regime doesn't only apply to non-European companies, it also applies when you, European business, do have and receive subsidies in another jurisdiction, so, and you come into Europe to make investment. So it's a long list of things that Valentina needs to take into account when, you know, advising to and trying to respond to that key question of how long it's going to take and, you know, how difficult it's going to be. So I'll let you comment, Valentina, more from a practical angle, how that plays out.
Yeah, thank you very much. Thanks, Linklaters, for inviting me. It's an honor to be here with you. So, as you mentioned, after more than a decade in ENI, I recently moved to ENI Plenitude as head of Anticorruption, Antitrust, and Financial Regulation Compliance. Both ENI and Plenitude are very sophisticated organizations which have been involved in a number of transactions around the globe, including in the past some that had to be solved with remedies, of course. I think that being a sophisticated organization has two main consequences, let me say. On the one side, our business team and our M&A team in particular are now very familiar with the antitrust compliance. The group delivers compulsory antitrust training aimed at teaching the business people on, among other things, of course, when a concentration arises. And so they are very aware on where they need to seek for our help. Also, accordingly to our internal rules, the antitrust compliance team is involved since the very beginning of a deal around the table and is always, let's say, kept update on the negotiation development. That say, I have to say that with Plenitude, I've experienced a slight change of the focus on my activities, since now my activities are now more focused on the two core business of Plenitude, renewable and e-mobility, as Annamaria was saying. These are new sectors in which, as Plenitude, we are still gaining experience. This means that, for example, we may acquire renewable projects which are yet to be developed, so we acquire a bunch of paper, in a sense. In such a cases, as you can understand, it's less likely to have substantial issues. Of course, the business focus is on time to close, so the first question of our M&A people, as we know, is how long we need to get the clearance, and so what we can do before getting the clearance. The second effect of ENI and the Plenitude being sophisticated organization is that, unfortunately, we have a very rich and consolidated internal case law when it comes to merger control. This has become a peculiar feature in the Plenitude world because our partner, compared to my experience in ENI SPA, are now very different from those I used to deal when I was in ENI SPA. First, we can have, let's say, as a partner, we close partnership agreement with small developers, which are highly skilled from a technical standpoint, but know nothing or almost nothing when it comes to merger control. And so from this perspective, with this partner, we as ENI team start from scratch. And often we need to behave as a guide and make them understanding concept like what is the relevant undertaking for the merger control purposes, or what is the local effect test, for example. Also, these players are often surprised to discover which are the timing implications and the boundaries stemming from the merger control. For example, gun jumping or sharing of information between the parties between the closing, clean team agreements, standstill obligation. The second kind of partner that in the renewable sector we can have are financial investors. And the financial investor in general rarely have notified a deal in the past, especially when you speak about foreign-to-foreign transaction. And they don't want to change approach because of the fear to open the Pandora box. Because as you know, when you file a transaction around the world, often in the filing, you need to disclose previous transactions that you have implemented before them. At the other end of the spectrum, we may deal with very formalistic partner who wants to notify a transaction wherever in the world technically the thresholds are met, without even exploring the possibility of, let's say, the existence of legitimate ground not to file. For example, by duly checking with local counsel if some exemption or according to the actual interpretation by the local competition agency can allow you to have ground not to file a transaction. Needless to say that this is an issue very complex for E&I, since we need to also guarantee consistency in our approach as E&I group around the globe. Just to elaborate on this, if I may, having the experience and internal case law very consolidated and sophisticated also means to be able, as in-house counsel, to take, when it's needed, a well-balanced calls on which jurisdiction to focus on, based on driver that can be, for example, the effect of the transaction around the globe, the multinational nature of the partner, the media coverage, and so on and so forth. In this respect, the support of the external counsel is crucial. Why the ultimate decision on if and where to file lies, of course, on the undertaking responsible for filing, the external counsel has a very role that I would define instrumental for us, because it's up to them to manage and handle the local counsel when some complex issue, such as the local effect test or the application of exemption, can arise. In this respect, we also appreciate that the external counsel have a different role than the in-house counsel. Of course, they are less exposed to the timing pressure and to the consistency issue that we have as in-house counsel. And finally, allow me this. The more filing the external counsel do, the happier they are, for obvious reasons. So that is why I can see a value in building a strong, long-term relationship with external counsel that know which is our compliance approach and can support us in ensuring consistency around the globe. When it comes to, if I can, give some practical example on my experience. I mean, there are a number of M&A transactions that I handle from a technical perspective around the globe, but let me focus on Plenitude world and Plenitude experience. I think that good example can be those where we have experienced the discrepancy between the European merger control regulation and the European member state national rules, in particular in terms of different requirement for a concentration to arise. For instance, once we had carried out an analysis relating the reportability of a joint bidding agreement. As I told you at the beginning, we are gaining experience, and therefore we often submit now joint bidding agreement with partners that, from a technical point of view, are very skilled. So while this transaction was, for example, in this case, not reportable in Europe because of the non-full functionality nature of the transaction, let me say, it was reportable from the day one under the local law on one of the member states. And it goes without saying that often one of the interesting features in this case that is very hard to explain to our business team was that after the filing in one of the member states, it could happen that in a later state of the deal, we should have been obliged to notify also in Europe. Other examples come to mind are relating to the full functionality nature of the joint venture. So, for instance, it happened that due to the need to close the deal in a short and fixed deadline, we have advised the business people to negotiate the commercial aspect of a deal that was not necessary to negotiate at that point because we need to close the merger analysis in time. So we advise the business to bring forward the negotiation of certain commercial aspects so that in such a way that the full functionality nature of the joint venture should have been ascertained in due time, and therefore the merger clearance obtained before the closing. Or again, always in terms of full functionality that you have to admit is one of the greatest areas in the merger control field. It happened to us that merger control had to be, the merger control analysis had to be carried out in a stage where the commercial people were not ready to negotiate, let's say, the commercial terms of the deal that are relevant for merger control purposes, because you can understand when you go with a partner to submit a joint bidding agreement and you don't know if the award will occur, you are not ready to say, okay, I will have staff in this joint venture, I will finance to third party instead of by the parent company, or I will go and sell the energy into the market. You have not an answer to this question. So our role in this case was to carry out a parallel analysis, one assuming the full functionality and the other assuming the opposite.
So, I mean, I think what comes across from what you explained, Valentina, is actually, and I'm sure for those who are in-house counsel here in the room, it is much more complicated than sometimes it appears as an external advisor. And also, I mean, going back to one of the points Daniele said, that probably sometimes external counsel do need to take off their hat of legal advisor and being a bit more practical and really understand what are the business needs more than simply, saying these are the rules so you need to comply with. So probably if you had to share golden rules that for working successfully.
Yeah, very simple. Be pragmatic, be friendly, be clear. Be clear, you need to always explain, not only internally, also with special partners such as small investor or financial institution, what we are going to do. And so also give background to your question is important, so people who are not familiar with merger control can understand what we are doing. Second golden rule, be pragmatic. Offer solution, which meets the business needs. So the in-house counsel is there to support the business and not to delay the project. So what we do, as I explained in the cases that I mentioned before, is always trying, in compliance with law, to advise people on how put forward and bring forward a project in respect and compliance with competition law. Be friendly. I always believe that nothing can come out of a distant and isolated compliance team. You know me, I'm not an introverted person, and I always try to build good and friendly relationship, always also with my business people. And this is important also when it comes to a technical matter as merger control, because our business people, when the first time that I told them that a project in Mozambique need to be filed in Poland, they were, let's say, like this, because why Poland for something that relates to Mozambique? So you need to be very friendly in order for them to understand what be compliant with merger control can mean.
Thanks a lot. Lucio?
Thank you, Valentina, for having shared with us your insights, the real-life issues that in-house counsel face, and of course the golden rules as well. So I notice we are slight beyond schedule, so I would close it here, and thank you.